Hi everyone, welcome. We're going to just give it a minute before we get started so that folks can join us from the waiting room. All right. Okay, so welcome everyone to today's event. While we wait for folks to join us, we can get started on some housekeeping items. Um, Thank you all for joining today's webinar on Pennsylvania's new landlord tenant mediation rule. I just want to quickly talk about the Housing Alliance. We are a statewide coalition working to increase access to safe, decent, and affordable homes for all Pennsylvanians. Webinars are free for members, so become a member today. You can do that by visiting housingalliancepa.org/become a member, or you can become a member by contacting us at info@housingalliancepa.org for more information. We do a variety of webinars on housing and related topics, so become a member today. All right, moving on to some logistics. Today's webinar will run approximately for 60 minutes, and that includes time for question and answer. We encourage you to leave questions to our incredible group of speakers today. If you want to ask the presenters a question, please use the Q&A function. You can find that on the bottom of your screen. The chat function is only to ask the Housing Alliance logistical questions about the webinar and to introduce yourself. So please go ahead, tell us your name, your organization, and where you're calling in from. We will also email a recording of this presentation and any associated materials in approximately a week's time. And just quickly, upcoming events. We have a few upcoming webinars. One of them is on Act 129, updates and next steps for Pennsylvania households. That will be on May 15th, 2026 from 11:30 to 12:30 p.m. You can also just scan the QR code that you can see on the side of the screen. That will take you to our events page. All right, and with that, I want to thank all of our speakers for being part of this webinar and for sharing their knowledge and expertise with our audience today. Please make sure to leave questions for them both. I'm going to hand it over to Gail Schwartz with the Housing Alliance of Pennsylvania to get us started.
All right, I'm just getting my slides pulled up. Great. So, hi, everybody. As Chris said, I am Gail Schwartz with the Housing Alliance of Pennsylvania, and today's webinar is Local Courts, Local Solutions, Pennsylvania's new landlord tenant mediation rule. Eviction is a cause of poverty, not a byproduct, according to Pulitzer Prize-winning author Matthew Desmond. An eviction on one's record, or even just the filing itself, no matter the outcome, can be a systemic barrier to decent and affordable housing, making it significantly harder for families to convince a landlord to rent to them. These families often end up in housing of poor quality and in neighborhoods with higher crime and poverty. And there is a critical shortage of affordable homes in Pennsylvania. And because quality homes are scarce, and an eviction creates one more barrier to obtaining a new quality home, preventing evictions to help households remain in their homes has to be a priority. So we seek to demonstrate that there are win-win solutions to eviction and how programs can be implemented at the local level. The Housing Alliance has prioritized scaling eviction prevention strategies and promoting the replication of these strategies across the state. We are always advocating for policies that will prevent evictions and protect renters. We research and promote smart practices at the local level that are showing impact in preventing evictions. We convene and engage those on the front lines delivering or seeking to create eviction prevention programs. And we listen to and engage with those with experience of eviction for their policy and program recommendations. And after all of this work that we've been doing for years, one thing we have found is that there really is a couple of key components that make for a really balanced, holistic eviction prevention program. And that is a program that is going to meet the needs of landlord and tenant. And we see that as seeing three key components. One is direct rental assistance. We're not looking for, something as broad or large amounts as we saw with ERAP, but just something that can really help somebody get out of that immediate rental debt and get stable going forward. We want to see high resource navigation, right? We want to make sure that we are not just looking at the rental debt, but we are also looking at what are the underlying issues that led to housing instability in the first place and the landlord-tenant conflict in the first place, and see if there's any resources that we can connect to make sure that we're not in the same situation 3, 6, 9 months down the road. And then the third piece is a dispute settlement component, something that's going to facilitate communication and negotiation. And one of the great programs and great resources out there that can do that is mediation. So I am so excited to have with us today. We are joined by Ann Herod-Stark, Chief Deputy Court Administrator from the 5th Judicial District of Pennsylvania. If anybody doesn't know their judicial districts by heart, I most certainly don't. That is Allegheny County. And then we have Matt Rich, Staff Attorney from Mid-Penn Legal Services, who did a lot of work in Dauphin County, but is now bringing his talents to Lancaster. So now that you know who we are, why don't you give us a moment to tell us who you are? Chris, can you please launch the poll? This is the second poll. We need the first poll of who is with
Sorry,
us.
Gail, hold on. Yes, I have launched that one.
Great. So, are you a housing provider? Are you a housing authority? Are you a CAP agency or nonprofit community-based organization that is supporting tenants? Facing eviction, legal services, maybe pro bono attorneys with that, landlords or property managers, tenant yourself, local government officials, community residents. We'll give it just about 10 more seconds. So we got a lot of nonprofit, community-based CAP agencies with us. We got a lot of housing providers, some landlords and housing authorities. So we got a great mix with us. I'm going to go ahead and end the poll. Oh, share the results. And then with that, I'm going to bring up slides for our first speaker, which is, our agenda. Sorry, I'm getting ahead of myself. So we do want to go over what this mediation rule does. There is a recent change that came out in October. So we're going to talk about what the rule does, how you can partner with courts, and how to get a mediation pilot going in your community. So with that, I'm going to pass it over to you, Matt.
All right, thank you, Gail. Good afternoon, everybody. Well, now I'm getting a lot of feedback, and I didn't have any until I came out. Or, sorry, am I creating feedback for everybody, or are we all right?
I think we're all right now.
Okay, good. Got it. Sorry, thanks. Yeah, so good afternoon, everyone. Again, thanks, Gail. So again, as Gail had noted, I'm a staff attorney at Mid-Penn Legal Services, helping low-income individuals with housing, do almost exclusively housing and utility work. I will kind of hang a little disclaimer on this that after I kind of cover my portion here, I'm going to have to run to another meeting, but certainly feel free to chime in with any questions here while I'm still around, or if I do have to head out, as Chris had mentioned, certainly put any questions, in the chat, or I don't know that we have a questions and answer section, but in any event, let the questions be known to the Housing Alliance, and she'll follow up and certainly can answer anything that you guys have on the back end here, even if I have to run. I'll note that, again, kind of also by way of background, in addition to my work as an attorney and helping tenants, I also serve as a member of the Pennsylvania Supreme Court's Minor Court Rules Committee, which is the committee through which this original proposal for this rule flowed and then ultimately went up to the Supreme Court for their approval. And I, in addition to that, have firsthand experience in working with Gale and the Housing Alliance, as well as with a lot of local organizers through our bar association, our mediation program, rental assistance offices. We had a mediation program running in the early days of COVID for a couple of, I think it was about a year and a half to 2 years in Dauphin County. So do have a fair amount of experience in trying to kind of take that from an idea all the way through the process of trying to work out the logistics and then putting it in motion and having a program up and running for a time. So do have a lot of experience in that regard as well. And again, we'll note to all of you that certainly willing to talk with any of you at kind of any point to try to help, especially if anybody's interested in trying to get a program up and running yourself. So to talk about the rule then, right? So what we're here to talk about then is this new rule that's going to take effect as of October 1 of this year. It has been in the works and had been in the works for, I think we're going on maybe 4 to 5 years now, if I'm recalling correctly. This was kind of a direct result of the groundswell of support that came from, whether it's legal aid organizations or even court systems, the Housing Alliance, this notion of like once COVID hit and we knew we were going to have to deal with, this kind of, I think the term of art was like the tsunami of eviction filings that were going to occur after the moratoriums ran. We really wanted to try to push and kind of capitalize on the kind of sentiments throughout the system and try to get some mediation programs going. And so there was a proposal that was sent to the Rules Committee. I believe it came and like originated out of Allegheny County, which I know Inherit can maybe talk to a little bit later. And then it made its way through the Rules Committee. And I am kind of duty bound as a member of the Rules Committee to not disclose any of the details of the communications of the committee, but I can at least just kind of say generally that the process is a little bit black box-ish as far as something that gets to the committee and then goes up to the Supreme Court. But by and large, the notion is that any of these sorts of things come to the Rules Committee. We consider them. We try to draft rules. We publish them for public comment then to let the public weigh in, make any changes, and then we ultimately send it up to the Supreme Court for the Supreme Court to essentially do with it what they will. If they want to approve it, they'll approve it. If they want us to make changes, they'll kick it back and they'll have us make changes. If they don't like it at all, they might just out and out reject it. And so, with that in mind, I'll just say that, again, this is kind of a standard process, because you might be saying like, I can't believe this took 4 or 5 years for this to happen, but this is a relatively, I think, kind of standard process, how that's made its way through the system. But we get the new rule finally approved October 1. The idea is, and I forget if we have the text of the rule in here, but what I will say, a couple of things about it. The one thing about the rule is that it doesn't make this mandatory. Like it allows for what I call like cover to local court systems and communities to partner with landlord organizations, with the court system, to try to work on, developing and then integrating into the system these mediation programs. Why does it matter? I mean, mediation is, oh, sorry, we're jumping around there, Gail. Hold on. You tell me when you're settled, Gail, and then I'll keep going. I don't want Okay, gotcha. All right. So, why it matters, right? So mediation, there's a lot of this stems from work that's been done for years now in Philadelphia. I'll spare you guys all the kind of details of the legal mumbo jumbo about why Philadelphia operates differently than the rest of the state, but just know that they do. There's a lot of things that they can do under the Home Rule Charter and the way that they're set up as a city of the first class that, again, just like they can do certain things the rest of us throughout the state can't do. But Philadelphia, through their process and their system, through their city council, like they did a report that took kind of a year's worth of studies and found that, as Gail had mentioned earlier, that like eviction like leads to poverty and then drains on the system. And so, with that in mind, like Philadelphia created this kind of system and program that they have in place where they're, creating funding that's made available for rental assistance, for these mediation programs to be kind of staffed in various ways by legal aid organizations, and, made mediation in Philadelphia mandatory before a case gets filed. All of that being aimed at trying to mediate as many cases as possible which we now have like a couple years worth of data from Philadelphia that makes it very clear. I forget the numbers exactly, that mediation does indeed help lessen the burden on the system. It reduces cases that end up going into court if you can get there, early enough, or even if you can't get there before filing. It certainly reduces the number of cases where there's either a judgment entered that leads to eviction, and so it reduces evictions across the board. It reduces courts caseloads. Certainly, of course, helps families stay housed. And one thing that I'll say is kind of a bit of an epiphany for me over the course of the years of talking about mediation here is I guess I think early on in my career I'd always kind of view the landlords as like, oh, big bad landlords just want to get rid of tenants whenever they can. And then once we got talking about mediation and I got working and talking with like more landlords and landlords organizations, like they made it pretty clear that like, hey, like if we can possibly salvage a tenancy, we would like to do that, even if not like, for the sake of the tenant or what have you, but even from our aspect of it costing us like thousands and thousands of dollars in turnover costs. Like if we, can actually salvage a tenancy, we're always going to default to doing that. And we're only going to move forward to evict if we think it's like absolutely necessary. And that, I think kind of hearing that, be said out loud, definitely helped me kind of take a different viewpoint on these things. And again, just one of the many different reasons why this is beneficial. So now, what does the rule do for us, right? So the one of the kind of the big things, right, is that again, I think of it as cover, because if we did not have this rule that we now have, if a local program wanted to get up and running, they would have to go to like their local court, see if their local court would sign off on it. And then the local court, even if they were willing to sign off on it, would have to send proposals up to the Supreme Court for approval before they could then come back and sanction it. Now, what the Supreme Court has done and what this rule does is it provides that cover where it says, we're already, as a Supreme Court, we're telling you any locality, this is anywhere across the state, that if you want to integrate one of these programs into the legal eviction process and system, court system, you can do that. You can do that just by a local rule that gets enacted, and president judges can just take it upon themselves to approve a local rule to that end directly, without then having to go back to the Supreme Court, which again would lead to like additional delays. So we've already kind of gotten out ahead of that, and we're giving that cover to the localities where the president judges can just go ahead and enact these rules and get it going, which again then enables that kind of faster community specific response to any particular housing challenges that pop up maybe in one area as opposed to another area. Go to the next one. Yep. Now, what the rule does not do, though, is number one, a couple things. Number one, makes it clear that it does not require courts to create mediation programs. So as part of being part of also the Rules Committee, I also train the judges through their minor judiciary education board and their continuing legal education programs. We've been spending this whole last year, dating back to like September, once we knew that this rule was going to be enacted and would become effective here later this year. We've been spending this whole training year with the judges on making sure that they're aware that this rule changes become effective, and making sure that they're on the lookout. But I'm often telling judges, like, just so that you know, this doesn't require programs. So it may very well be that we talk about it now, and there's a possibility you might not ever see or hear of it ever again. But just know that this rule is out there, and you might start to see these programs get developed. And so to the extent that they do, be on the lookout for it. But it doesn't require them, number one. Number two, it makes it very clear that mediation cannot be made a mandatory pre-filing requirement. So again, in utilizing Philadelphia as an example, they have a local city ordinance that requires every single landlord, before they go to file in magisterial district court, they have to then go to mediation first, go through that process, and only if that mediation process does not work can they then go to, again, out there it's municipal court, but not magisterial district court, but municipal court out there, they can then go and file a complaint. But they are mandated to go to mediation before they even file. We do not have that here. This rule specifically says that we're not allowing that to be part of any mediation program and local rule that might pop up as a result of this statewide rule. So we have to think of that then, and to the extent that anybody's going to be working on one of these programs, that any mediation program that you are going to try to enact and get working with your local court system on has to try and fold into the existing process, right? Try your best to get notices out there in advance and see if you can get landlords and tenants to submit to mediation voluntarily before they file, if possible. That's, difficult, but that's what we're shooting for, trying to avoid a filing in the first place. If we can't avoid a filing, can we get in there and get notices sent out along with the hearing notices so that, like, before the hearing is held and before a judgment's entered, maybe we can sneak in there and get mediation done, and we can try to get the matter resolved, even if there's a filing, before there's a judgment. And then there are even certain instances where, even if a judgment's been entered, there is some time frames available where you can try to sneak in there, kind of, even if it's like, say, last minute, and you might say, hey, we know there's a judgment entered, but we'd like to try to mediate this and see if we can work something out. And there are ways to potentially attack it even at that point in the process. But the idea is we just can't make it a prerequisite to filing. It also does not provide any funding. So, certainly do know that to the extent that you're going to, try and start working on a program of this nature, like, this rule does not provide any funding, doesn't, necessarily provide any avenues to funding. It's literally just saying, hey, if you guys have, funding available that you can get your hands on and you want to create a program and weave it into the existing system, you can do that. But certainly, we'll surely talk about this more. I mentioned it a little bit that certainly court systems and magisterial district judges are still going to need, like, education and advocacy about this. And we're certainly trying to do our part to get the word out there when we're doing these training sessions. And that's with every judge across the state. So, like, technically every judge across the state that you might encounter will have been trained on this topic at least a little bit. Whether or not they're going to retain all of what we discussed during those training sessions is a different story, but they've at least been introduced to it. But just know that to the extent that you're going to work on a program, you're going to have to really try and latch on to a judge or judges in your area to make sure that they're aware of what it is that you're trying to do and that they're aware that they can try to work with you in that regard. I'll go to the next one there, Gail. Okay, now, to go hand in hand with the mediation rule, the one rule so, like, I end up kind of telling the judges, it doesn't really change what you're doing at all, just lets it be known that there could be these local rules created. What I do tell the judges, though, is that the one change that went hand in hand with that does matter for judges is the rule change with regard to continuances. So before this rule change, the most recent one here that, again, goes into effect in October, MDJs, with any case that they had for landlord tenant, if the parties came in and said that they wanted a continuance, it's at the judge's discretion to continue it. And even if a judge wanted to continue it, there was a 30-day limit on the judge's ability to continue the hearing. Now, there's always been written in the rule this, like, agreement of the parties exception that would allow judges to take cases beyond 30 days. But what we've done now is we've made it clear in this rule by changing this and editing it a little bit that it can either be for good cause shown or an agreement by the parties that the hearing can be continued beyond that 30-day limit. And a lot of judges are concerned about that because they get audited by AOPC. And, like, if AOPC sees the case has been in the system for a while and there hasn't been a hearing held, they might come and ask the judge, like, hey, why is it that this case is still open? And so this rule does, again, provide coverage for the judges to then work with these programs. And so long as they have something that shows some good cause or shows an agreement of the parties, they can extend it beyond that 30-day limit. And so one thing I will note, if you are working on any of these programs, is just be leery that if you are working with the judge's office and they're willing to try to work with you, just know that anything that you're doing with the landlord that you're trying to, like, extend a hearing and move it, just know that you're going to ultimately have to put something in writing and send it to the judge's office that just confirms that the parties are in agreement to move it. And by and large, I think most judges, especially now with this change, so long as they know that the parties are in agreement, they're going to be willing to move it. But the last thing I'll note on that is just know when we say good cause shown, the rule makes it very clear that good cause shown does not equal a tenant participating in a mediation program. So when you're just because a tenant says, "Hey, I called the local program and I'm trying to work with them, I want a continuance." If the landlord is in there and says, "No, I don't want to mediate. No, I am not in agreement with this. I just want to move forward." The judges are going to then look at that and say, "Well, sorry, that does not equate to good cause shown. I'd like to work with you, but that does not necessarily equate to good cause shown." So it really does require, like, I mean, and what you want to shoot for is buy-in from both the landlord and the tenant, if at all possible, just to lock that in. I will just note that's, I think, the end of my portion of this. And again, I'm going to probably run in a couple minutes, but certainly anybody chime in with anything if you need me before I leave, or feel free to follow up. Otherwise, like, thanks, Gail, and I'll turn it over to Ann Herod then.
I am on mute. So while Inherit is getting set up, we do have another poll. Oh, all right. I am lost. So we do want to do just a quick check. How many of you out there have started a landlord tenant mediation program or looking to start a landlord tenant mediation program? You know, this, as Matt said, removed a significant administrative burden barrier for working with local courts. And so we are hoping to see people start to think more strategically about getting these programs started. So I'm just going to give it about another 10 seconds for folks to answer. All right, I'm going to end the poll and then share the results. And it looks like we have over a quarter of folks are looking to start a landlord tenant mediation program. Some folks already have a landlord tenant mediation program, but it doesn't work with the courts. And there's a few that are already working with local MTJs. So that's really, really exciting to hear. And with that, I'm going to stop sharing my screen. And I am going to pass it over to you, Ann Herod.
Why, thank you, Gail, and thank you for including me in this presentation and webinar. As I've been introduced, my name's Ann Herod Stock. I have been an attorney for a very long time, but my first part of my career was all in criminal law. I knew nothing about the world of landlord tenant law until I began to work with our court administration. And then it really came to a front during COVID. And as horrible as that was for many, many people, on one glimmer bright side, it did in Allegheny County bring people together to discuss the issues of evictions and landlords and tenants and how to better work through this system that's so laden in the rules of procedure. So through that sort of initial working group to help Allegheny County with the ERAP money and whatnot get through the whole COVID crisis, then out of that came the concept of pushing for a more robust mediation system in landlord tenant cases in Allegheny County. Now, I have to start with a disclaimer. We have not started any of this yet. So Matt was correct that we were one of the requesters of the rule changes to the Minor Court Rules Committee. I, too, was a member of that committee and realized without some rule changes, it was always going to be stopped. Like, this was never going to be able to go forward as we would have liked. It took a long time to work through those rule changes, but it also took us a long time to get to that request in Allegheny County. So now that the changes have occurred, we're now in the process of figuring out where to go next with the changes and how to make it work in Allegheny County and from beginning. So I'm sorry. So one of the things that I think is really important is I think it's really important, and every county is a little bit different. Just some background. In Allegheny County, we have 46 magisterial district courts, so it's 46 judges. It's a little untenable for mediators and providers to meet with all 46 judges. So we have kind of had court administration, which is the entity that oversees the court system. It falls under the Administrative Office of Pennsylvania Courts, the AOPC. So court administration has taken the lead. We bring judges in to help develop these procedures. And we had a little working group back in 2021 and 2022 of magisterial district judges, court administrators, mediators, people from all parts of the eviction world and the landlord tenant world. So one of the big things that we have in place already, which is a huge relief, is we've already developed the procedures for the courts and the dispute, alternate dispute resolution providers to go by. By having a set of procedures, we will have hopefully efficiency, consistency, and then we'll be in a better place to enact our own local rule to put these procedures into place. In order for an AD mediator to be approved, it has to come from the president judge of the judicial district. As I stated before, communication with the court administration and the judges is key for anybody who's starting or wants to start a mediation process. I think you have to go to those entities in order to explain why it works, because there is no court funding for this. That's very clear in the rule. It's very clear in the comments to the rule. But this is an unfunded process and project. And we're fortunate in Allegheny County. We have a robust Department of Human Services. We have a nice foundation community that will help us with this, hopefully. I'm sorry, it's not going forward. Are you seeing the next slide or no? We skipped one. All right, so I'm just going to run through how we foresee this process working. Is that at the time a landlord tenant complaint is filed, and you can file those in person, you can file them through the mail. An ADR information form will be provided to the landlord at that time. If they come in person, we're going to encourage our staff to remind landlords that they can do the mediation before filing a complaint, and therefore maybe never have to file a complaint, and that there's no cost for the mediation. We're trying to make it as easy as possible for people. So we're hoping that intake forms would all be completed online at the magisterial district court. We plan to have kiosks there with the forms on them that people can go online and fill it out, and it would go straight to the provider for the mediation. We also plan to put the forms on our court website so people could go in there and gather the forms. That also as Matt pointed out, there is no mandatory pre-filing mediation. So that's something that we did not ask for, and the Supreme Court, I don't think can approve, because not every county has the ability to provide mediation. So our process for the coordination and timelines is that our providers to contact the parties within 2 days of receiving the form. Mediation really has to occur like 2 weeks before the hearing date. You're supposed to schedule them by the rules 15 days after the complaint's filed. So we really wanted to push everything on the front end to get things moving. But that's where the postponement changes come into play, because the judge has the ability then to postpone the case beyond the timelines in Rule 209. So, so I'll move on to the next slide. So as the continuances with Rule 209, that cases may be postponed based on agreement of parties or good cause shown. Generally, that gives the judge some leeway also. If one party is not cooperating with the mediation, then they can kind of stop it at that point in time. The process that we'd like for the mediation is preferred video. Trying to bring people together, especially in large counties, can be difficult. There is an in-person option if that would work for other people. When we decided on our process, that included a mediator and a resource navigator. during COVID, that was one of the key issues, was connecting the people to the resources that were available. Back then it was the ERAP money. Now we still have some other resources, but people do need help connecting to those resources. Sometimes our DHS, Department of Human Services, is helpful with the resource navigation, but we're hoping to put that into our process. The resource navigator person would assess the needs, help complete applications, and prepare the parties for the mediation. The next part of our process is that the provider needs to communicate with the court. They need to file status report 5 days before the hearing scheduled, including the cooperation, the status, whether continuances are needed. And at that point, the MDJ may grant a continuance of the case if things are going well and the mediation seems to be working. If the case is concluded, if the mediation is settled, then the notice is sent to the Magistrate District Court, and then the case will be dismissed, I believe. That part we haven't quite worked out yet. If there's no mediation settlement, there'll be an exit form, and the case will proceed like a normal landlord tenant case to a hearing. There are some exemptions. We encourage everyone to be part of the mediation, but in order for agreement across the board, we do have some exemptions from the process. If the complaints alleging criminal activity or exigent or emergency circumstances where there's a health risk in the unit or something of that nature. But the landlord needs to submit this request. We haven't worked this out yet, but probably in the form of like an affidavit or a petition. The Magistrate District Judge will either deny or grant the request. If the judge feels a hearing is necessary, then they'll have a hearing on that request to be exempted from the ADR process. Sorry, I'm slurring my words. The other important thing to make any of this work really is data collection. And I think if you want a successful program, you need to prove that it's successful. You need to track your cases, you need to track the outcomes, maintain these statistics, and that will help everyone evaluate the program's effectiveness and then moving on. In Allegheny County, because we have 46, there is discussion of starting with a set number to kind of do a test of them, whether it's 6 or 10 courts, just to ease everybody into it. And my hope is that it's wildly successful. So therefore, other judges and other landlords want to take part in the mediation once we can show them the data of how well it's working. And with that, just the data, and the next slide is not coming. So, I mean, as you all know, the mediation will improve efficiency for the courts. I mean, you would lower the number of hearings you would have, lower the number of, obviously, evictions, of court orders, just things of that nature. However, it does require a great deal of coordination and oversight to make sure that it's working in the way it's supposed to protect all parties to a case. I think it's important to note the court is, I'll stop sharing. Can you hear me? Yeah, the court, and I say this a lot in our cohort meetings, is an objective party to these cases. We don't have one side or the other. We're not on the landlord side. We're not on the tenant side. They're the arbiter of the facts and the legal issues in the case. So it's important that they maintain that balance. But I think we're hopeful that we can get our mediation program off the ground and running in the next 6 months to a year. And once we do that, I hope to report back that we're wildly successful.
Well, I hope to have you back to report that as well. Just a quick clarifying question. What does MDC stand for?
Magistrate District Court. I'm sorry. Yeah.
Yeah. And then
MDJ is Magistrate District Judge.
Yeah. And how do you access a DHS resource navigator for mediation?
Well, I think you'd have to work with your DHS department in your counties and see if they would help you do that. Or maybe a foundation could help you find a resource navigator or fund something like that in your area. That was in that piece. I hope it doesn't leave, because I think that's one of the most important pieces. I think the mediators have to be doing the mediation. They might not have the time to find the resources that are needed. And a lot of the mediation is going to depend. We still have to keep resources for people. If they don't have resources to help them with rent, with utilities, things of that nature, it's hard to mediate those. So I know the money is not as robust as it was and whatnot, but at the time we kind of drafted this, there was more money involved and more resources available. But my suggestion would be to work with your Department of Human Services. I mean, Human Services, where people live, is a big component of that. And evictions hurt all across the board. They hurt the child welfare system, health, all of that. So, but if they're not willing or able, then my suggestion would be maybe turn to a foundation in your area or surrounding areas, things of that nature.
Right. Because this is what you're doing in Allegheny County. It can be done in other places, but it's most certainly, it seems like you guys are further along in creating this court-connected ADR program than other communities. So I could not have paid you to do a better tee-up for our next part of the presentation. So thank you, Ann Herod. And that is the eviction prevention incubator, right? So the Housing Alliance has developed a new technical assistance and training product to help communities really create eviction prevention programs very similar to what Ann Herod just discussed. It does take a lot of different people coming together, different stakeholders. You want your local government, Department of Human Services, behavioral health, your homeless assistance providers. You need court and court staff at the table, funders, foundations. A lot of different stakeholders came together to support the folks in Allegheny County and getting these programs going, and that can happen anywhere. And for us at the Housing Alliance, that is absolutely something that we love to do. So we have this incubator. It is a structured, time-limited workshop designed to nurture new ideas into actionable strategies. And it brings together those cross-sector partners to co-create solutions, to come up with models, and to lay the groundwork for implementation. So what we do is we use an interactive training and facilitation. We spend probably 2 to 3 months with a small planning committee preparing for this. We do local data analysis on the local landscape of evictions in your community. We do resource mapping. We do very targeted outreach and power mapping and identifying key stakeholders to participate in the training itself. And the day of, we use interactive training and facilitation. You can see a picture here of people playing our little true-false game. We give them signs as we go through what are some of the myths and misperceptions around eviction. We use data-driven, evidence-based models. We highlight the great work that is happening in communities around the state. We highlight, what's happening in Chester County. They have a really strong eviction prevention case resolution program. Mediation, even though the ADR program that Ann Herod was just talking about is a new evolution that is going to launch later this year. Landlord Tenant Mediation has been on the ground and working at scale in Allegheny County for a couple of years now, and with great success. Over 98% of landlords and tenants who participate in mediation are able to come to some sort of compromise and reach an agreement. And we look at leveraging those existing resources, right? We map the existing resources. We see maybe we can, move resources to kind of intervene at different phases of the eviction prevention crisis. And so we break that up into different phases around pre-crisis and early risk, the pre-filing phase, notice stage, what can be done when there's a filing at the court, what are interventions for the court hearing, what happens when there's an order of possession post-judgment, and what happens if there really does need to be a physical ejectment of the tenant from the unit. So we look at, what do you have already? And maybe we can realign some resources to work better and to maximize them a little bit better. And then we start to look at, what is the design? And we know that we can't solve the eviction crisis in an afternoon or solve the housing crisis. So we really try to break it down to, if we wanted to create a pilot for just 20 households, what do we have in the community in place already? Where are the gaps? And what would we want to make sure that we had a strong holistic eviction prevention program that had that direct rental assistance component, that high quality resource navigation component, and that conflict resolution component, which is mediation or alternative dispute resolution. So for those who are interested in that, all you have to do is contact me. That's my email. I also send out a lot of emails. I'm hoping everybody who's on the webinar today has at least gotten an email from me once. I am happy to talk about what is going on in the community. So that's what we're doing at the local level. I also see a question in our Q&A about what is happening kind of at the state level. We're always trying to push for resources that can support these local programs. So we definitely have our homelessness prevention funding proposal where we're looking to get a small pot of money, about $20 million, created at the state level, a grant program. We are currently talking to legislators and seeing, is this something that can be incorporated into the upcoming budget? Is it, something that needs to be a standalone? So we have a number of organizations that have signed on in support of that, and we can, are continuing to collect that information. So if anybody wants any additional information, we did do a webinar on it back in February. We can include that link in our follow-up materials. And of course, you can always reach out to any Housing Alliance staff person. So with that, I'm going to stop sharing my screen and see if there are any other questions.
I don't see any questions in the chat or in the Q&A box. But everyone, we have some more time. Please feel free to leave the questions. You can put them in the chat as well. I am keeping an eye out. We do have a lot of thank yous and great works.
Well, thank you. Thank you. It is always really great. I think, one question that I do have, Anne Herod, if, you are trying to start a conversation with your local courts, how do you break the ice?
Or not as scary as we may be perceived, but it depends on your county and how they work. But, if you have one magistrate district judge that is in favor of this, maybe they can give you the entree to the court administration. There's also, every county, their magistrate district judges belong to the Special Court Judges Association. So that might be an entree, or just call your court administrative office. I think every district has a website, or the AOPC has contacts. The district court administrator, it varies from county to county, but every county has what's called a district court administrator, and you could always start with that person. They're the person that handles everything, and then they could go to the different deputies below them. The other idea, maybe down the road, like maybe next year, the court administrators have an association also called PACM, Pennsylvania Association of Court Management, and they have two. They can do like a webinar through them also to just explain what mediation is, or they also have two conferences a year. If maybe the Housing Alliance or somebody wanted to present at those conferences, you could do that as well. I can get you those contacts, Gail.
That would be fantastic. As much as we love to have you come to our venue, we are 100% available to come to your spot. I think, as long as we can just all keep talking and brainstorming ideas, we know that every community does have, some differences and may have different organizational needs or challenges. The courts, they have an operation sides just like the rest of us, and they have rules and procedures and process just like the rest of us. And so I think it's always mindful that it's not just the value of the idea, but process and structure does really help drive the conversation. If you are coming from a place of, please let me know what your limitations are and where you have some flexibility.
And I'll share that we have a conference coming up in a few weeks, and there's a section for the Magistrate District Court breakout administrators. So I will mention all of this to them as well and put them, on the lookout that they may be receiving calls from different mediator agencies and things like that. I mean, we haven't started our program yet, so I'm hoping it works well.
Yeah. Well, I mean, like you said, you accidentally muted yourself.
I'm sorry. I think it's communication really obviously is the key. And as every party can discuss, and we learned that during COVID with our little cohort group, that everybody has the same goal. People need to be housed. Landlords want people housed. Tenants need to stay there. We all can work towards that in a better system, in a better way.
Absolutely. Let's see.
We have a couple of questions in the chat, one from Rita, one from Kim, and then we have a question in the Q&A box as well.
All right, I'm going to start with the Q&A box because that's what I have open. Does the community need to sign up for the incubator with multiple collaborators, or does an organization go through it with people from other communities? So the way the incubator works is we really do sometimes, if you have like two smaller counties that like work together often, we have done that. We did an incubator in the Lehigh Valley, so it included folks from both Northampton and Lehigh. We also did an incubator with Cumberland and Dauphin together. That Matt participated in the fall of last year. So it can be a couple of different communities. It can be just one community, but just reach out to us. Like I said, there's months of planning where Housing Alliance staff is there to support and guide every step of the way. So you don't have to necessarily figure it all out on your own. Let's see, do you have information about corporate landlords and mediation? We don't have anything that's like specific by like what type of landlords, but that is something that we are interested in understanding better, and is something that we are looking into. So as we continue to have this conversation and continue to have these webinars, we are hoping to dig in deeper to, how do you partner well with landlords? How can we work specifically with corporate landlords who may often be using eviction filings as rent collection more so than actually trying to get somebody out of the unit? And, how can we incorporate mediation into that business practice and take the court out of it? So I'm going to move over to the chat. Do we have cost estimates? So I think it varies by community that we've seen. We've seen communities where they hired an in-house like staff mediator, or we've seen models where they provide stipends to train mediators. I don't know, Ann Herron, in looking at the ADR pilot, if you've gotten as far as cost estimates yet.
No, that would really be up to the provider to determine what for the court. It's a minimal cost if we put Chromebook or something in the lobby of each court facility, and forms are easily developable, but it's the cost of hiring mediators. I'm not sure. I think you'd have to look to the nonprofits that do that to see what their budgets are on that.
Yeah, that is one thing that we have seen, that oftentimes it is the social service partner that's going to be doing a lion's share of the fundraising, just because they have a bit more flexibility in pursuing different funding streams than the court itself. Let's see. And again, somebody is asking for the name of PAC. I think that's the Pennsylvania Court Clerk.
Pennsylvania Association of Court Management. I can put that in the chat also, and then you'll have it.
That would be great. And then, yeah, we see somebody from Allentown. I'll be sure to follow up with you afterwards and send you information about the Lehigh Valley incubator that took place last fall. So it looks like we've gone through all of the questions. We're rounding out our hour. Again, I want to say thank you to Ann Herod for all of this great information. And she has just been like such a great advocate and court partner on the ground in Allegheny County. I know this because the Housing Alliance is statewide, but I am based out of Pittsburgh. So I have been in many of these meetings and cohort meetings, and having an ally like that within the court system really helps move this forward. So thank you so much, Ann Herod, and for sharing that experience with all of us today. So thank you everyone for joining, and we will see you at the next one.
Thank you.